I got kicked out, but then I came back in. Ship, can you hear me?
I can hear you now. I couldn't until
Okay,
just a moment ago.
fantastic. All right, and people, let us know. Last night we had a lot of problems with the audio, or Sunday night, we had a lot of problems with the audio, cutting in and out, which none of the speakers could hear the cutting in and out. It sounded perfectly clear to all of us, and it recorded clearly. So I think that was the problem with Twitter's audio transmission. Hopefully, we're not having that problem tonight. Drop a comment in the comments. Let me know if we're coming through clearly. So, tonight we're going to talk about the Fisher argument in Supreme Court this morning. We've got Shipwrecked, who I assume everyone knows, but in case you don't know, we're all lawyers on the call tonight, and he's currently handling a bunch of the J6 cases. Longtime federal prosecutor. Now, is it 10 years you've been practicing defense work now, Ship?
11.
11. Okay.
2013 to 2024.
Aha. Okay. And as I'm sure most of you guys, if not everybody knows, I am retired now from practice of law. I practiced white collar criminal law mostly for 26 years, and then decided that I didn't want to do it anymore because of the problems, of which there are many that I think there are in the federal courts. And so we also have Kingmaker. Kingmaker was mostly a civil lawyer, right, Kingmaker? But you did some criminal work, but you've been practicing law. You're retired now too, right? Though 50 years.
50 years, a lawyer, retired for about 6 of them.
Mm. Okay. And then I've got my husband here with me. He may or may not chime in. We'll see. But he's sitting here with me tonight, also a lawyer, long time prosecutor, even longer time defense lawyer, 50 years, I think, practicing law as well. And a couple of times he's argued in the Supreme Court. So we've got folks with plenty of experience to talk about what happened today. Now, what happened today was, what do you guys think? Largely what we expected, but as always with Supreme Court arguments, never completely predictable, right? How do you guys think it stood up to how we described it on Sunday?
I thought that, well, two things. I thought that the judges expressing skepticism were a little more strident than I anticipated, a
Yeah.
little more, just outright dismissive of some of the justifications and rationales offered by the Solicitor General. Is it Elizabeth Prelogar? Elizabeth's her first name. And as someone who has now handled more than 50 January 6 clients, I was shocked by some of the concessions that Prelogar made in some comments that were simply contrary to arguments that are being made in court. The gulf between some of the things she represented to the court and how the same issues are being argued as a matter of, dictate in policy by line prosecutors in the district courtroom of the trial courts is quite dramatic.
All right, I want to do a clarification there because it sounded almost as if you said lying prosecutors, and I think what you meant to say was line,
Line,
Line.
yeah, line prosecutors, the
Yeah,
trial prosecutors, the people that
yeah.
I'm in court with on a weekly basis. The way that they and there is not nearly as much individual freedom of judgment allowed in the Department of Justice today than when my first 10 years as a prosecutor. They aren't given the freedom to think for themselves and frame their arguments the way they want to. They are very driven by narrative, and there are some things that they just are absolutely forbidden to say, and some things that they're told they absolutely have to say. It's reflected in all their paperwork. It would not be so consistent across so many cases involving so many dozens or hundreds of trial prosecutors, but for the fact that it's being handed down to them from above. And the solicitor made some comments and concessions, and I, sort of went after somebody on X earlier today and said, I'm going to feed a lot of her comments back to these prosecutors in written briefs with long passages of things that Preligar said to the Supreme Court today.
Right. I'm not surprised because my jaw dropped several times at stuff she was saying. Look, Kingmaker, you jump in here. What did you think? How it compared to what we talked about?
We went into this believing that these January 6th cases and the Trump cases were the front line, the first time this statute had ever been used this broadly. Frankly, when the one of the justices asked the Solicitor General about that, tell us about when you have used this statute, this C2 statute before. My jaw dropped. Unfortunately, none of the I think the justices were too prepared with their own digs at the government's position that they left it alone. But the three cases she outlined that I was not aware of, should have been aware of one because it was noted in the briefs. The first one, the one that she said is public, was a case in which the defendant had forged an order by a judge, forged the judge's signature, and presented that forged order to the other side in a lawsuit to get a dismissal, a voluntary dismissal. That was.
She tried to say that somehow meant they were using the statute outside of the way that Fisher's lawyers are arguing it, but I don't think that's correct. Do you?
That is a broad reading of even the government's position, but the two other incidences she outlined, that's where my jaw really dropped. One,
She was talking about. Go ahead. Go ahead.
yeah, well, one was they prosecuted somebody for tipping a person, that person was the subject of a grand jury investigation. And another one tipping somebody that they were the subject of a search warrant. I would never in my wildest dreams have thought that they've used this 20-year prison sentence statute to prosecute a tipper like that.
Well, they probably didn't have anything else that was going to apply. But Mr. Fisher's lawyer, Mr. Green, he conceded that the section of the statute that we're talking about, which is not tied to documents, records, or objects, could be used for things other than documents, records, and objects as long as they were evidentiary in nature. And so I didn't think that those three cases, the tipping off whether someone's going before the grand jury, tipping off whether someone is an informant, and falsifying a document to persuade the other side to drop their case, I don't see how those aren't also evidentiary based questions, problems, issues, whatever you want to call them, and therefore properly included in this section, which Fisher's lawyer said that's what he thought too. So
How do they obstruct, influence, or impede an official proceeding?
well, the other examples he gave were of a similar character too, and I think helps understand why that is. So he said, for example, he didn't think he could disclose the witness list outside of, to maybe to the client, because that could result in intimidation of witnesses. So he was trying to say that the statute covers things that are really related to the truth finding function surrounding the evidence, which he included as testimony, right? Um, for an official proceeding. That made sense because I had been wondering this same question too. All right, if C2 is going to mean anything, then what would be included beyond what's in C1? Because the whole point of C2 is things that are similar to C1 but that are not listed in C1, right? And I forget which one of the justices asked him that question directly, like what would be in there? It might have been Justice Jackson. And he said, well, for one thing, C1 prevents you from destroying, mutilating, blah, blah, blah. It doesn't talk about fabricating or creating false evidence. So that would be an example of something that would be in C2 instead of in C1. And then the other example he gave was the case that the Solicitor General talked about of creating this fake court order. And that fake court order was sent to the other side to get them to drop their case. He said he thought that was covered by C2. That made sense to me because in both of those situations, you still are monkeying with, to use a non-legal term, right? You're still monkeying with the evidence that's going to be presented or could be presented in a case. Same thing with you're by disclosing witness names or tipping off who's testifying in the grand jury. You're monkeying with the presentation of evidence to the tribunal, right? Or that could be used later for the tribunal.
I have to disagree. I don't think that's monkeying with the evidence. Uh, the tippee then might use that information to monkey, but the act of tipping does no such thing.
I
I've
think
Well,
the
had
what's
fa- I
clients.
interesting
think
is
I think
that
the
that
fact
oh,
I
but
think the
wait, wait,
facts
wait,
in that
wait, wait,
case.
wait, wait, wait. But that drives us into a question Justice Barrett asked, which was, does C2 carry with it the same specific intent requirement that's in C1, which is the government would have to prove that whatever the monkeying is was with the specific intent to impair the whatever it is for purposes of the case. So if you carried along that specific intent also, then that makes sense to me. You would be able to say C1 is parallel to C2. It's just different ways of doing the same thing. Now, the Solicitor General didn't really answer Justice Barrett's question about that. She evaded that. So, but so to
I think
answer your question,
the facts of that question, the facts of the case involving disclosure of the witness list were that the purpose was to dissuade witnesses from testifying.
right. Well, Green was positing that as a hypothetical, not as a case. He was saying that would be an example. The ones that were actual cases were tipping off that someone was an informant, tipping off that someone was going to testify in the grand jury, and this fabrication of the court order. Those were the three cases that the Solicitor General said in fact existed.
And on that point, that was interesting because later one of the judges asked her, "Well, have other maybe in Thomas had asked her, well, are there circuit court opinions that have
Mm-hmm.
interpreted C2 consistent with your position here on Fisher?" Oh yeah, we have a string cite,
Yeah.
of all these other cases. Like, well, if you've got a string cite, why are we only talking about three examples?
Right, exactly. I thought that too. Well, why aren't those in your discussed in your brief, not really string cited in your brief, right? So, well, King, I'm interested and intrigued by your position because I thought we were all in agreement. I pretty much thought everybody was going to agree. C2 has to mean something, right? There has to be some things that fit in there.
It yes, and I think the the conservative members of the court were focused on C2 being a subset or a different variety of evidence impairment.
Right.
And my point on the maybe I didn't understand the facts, maybe they were conspiracy cases, but
Mm,
but the fact that I've got a neighbor who gets a grand jury subpoena, and I call up the person I know is being investigated, and I say, my neighbor got a grand jury subpoena. Does that put me in jail for up to 20 years? That
Well,
to me,
let's say it this way. If you did that because you knew that if you did that, that your neighbor, who's really the target, would go out and kill that person, then maybe, right? Like if you did that for the purpose of impairing that person's presentation to the grand jury, which seemed to be Justice Barrett's point, right? That if you interpret the statute the way the government wants to, they could evade some of the requirements which are in C1, one of which is you have to have the specific intent to be impairing the evidence.
but
Oh.
without an agreement or now a specific knowledge
Mm-hmm.
that
Mm-hmm.
somebody's going to act
Yeah.
wrongfully on that tip, uh, I don't know how you get there.
Right.
From a
I agree with you on that. I think we're on the same page. And the Solicitor General's description of those tip cases didn't give you enough information to know whether, yeah, whether that was there was a conspiracy or the tip was made to, the defendant who then turned around and was going to do bad things with it. They just didn't say. But
yeah,
I
yeah,
just, yeah,
it could be nothing more than a tip. Heads up, Mister
right.
Potential criminal defendant. You may want to go get a lawyer.
Well, hey, King, I mean, we heard over and over again from the Solicitor General that we should really trust them, that they're only going to bring these cases when it's really bad, right? So, I don't know what you're complaining about here. If it was just merely, innocuous stuff, clearly the government wouldn't prosecute those cases.
Yeah, right. We learned how that works in yesterday's
Right.
hearing.
Yeah, exactly. So, but it did seem to be a bit of a bombshell in the argument, didn't it? That everyone seemed to be operating on the assumption that there were no other cases. In fact, the Court of Appeals says so in their opinion, that there were no other cases that were applied in this same way, or to this same kind of non evidentiary based kind of problem. And the solicitor obviously was prepared for that. So she threw up these three cases. But to my eye, those three cases are evidence based cases. They are talking about interfering with informants or interfering with the grand jury or interfering with the whether a case is going to be filed or dismissed. Those are still tied, I think, very closely to evidence questions, which is not what the J6 cases are doing at all, not even close.
I agree that they could be tied to evidence, but
Right, exactly.
to me that's a very long leap to get
Mm-hmm.
to evidence from
Right.
the mere fact of a tip.
What I was really struck by in her defense of their interpretation was when she tried to explain as C1 is what is specifically encapsulated by C1, and then C2 is the rest of the universe.
Right, the rest of everything
I,
else. And
really?
trust us, we're going to be
That's
really careful about
yeah,
using that. We don't trust
that's
you.
how we define criminal conduct. Everything else
Right.
that
How
maybe strikes the government at some point in the future as being, oh, we don't like that.
Right. Well, I mean, at least Gorsuch and Alito seem to have no use for that argument at all, right? Just take our word for it. We're only going to go after the bad stuff.
But but
I mean,
like
Alito
like like
blistered
pulling
her.
the fire alarm.
I couldn't believe Gorsuch went there, but he did, you guys. He asked her a series of hypotheticals, which weren't really
They were
hypotheticals.
real.
They
No,
were
they
all
were actual
actually
examples.
there. They were real world examples, but the Solicitor General said, well, all of those hypotheticals somehow wouldn't fit into her definition of things that should be
Well,
prosecuted.
but that's the big
Um,
problem because she said, well, we
yeah,
consider that minimal, and we read obstruction as
yeah.
requiring more than minimal interference. And then
Well, Alito said to her, "Where's that
well,
in the
and yeah, and
language?"
he
Which,
said,
of course,
wait, you're talking about plain meaning. You're defending this on the
Right.
basis of plain meaning.
Worse than that, he told her, "You're preaching plain
Right.
meaning." How does that square up with
Right.
it?
And
Right.
oh yeah, I mean, it was look. It, I listened to her. It was a shit show. I'm listening to this
Right.
thinking, and it's
Yeah.
so there's so much distance between some of the things she said, and I said this already. Some of the things she said and what the line prosecutors have argued in paperwork in the trial courts. Just it's crazy.
Well, as a civil libertarian, I sat there horrified listening to her basically say that even if the conduct that people were doing was arguably peaceful protest, even across the line into civil disobedience, that it could still be prosecuted under this very serious charge, um, because if in the government's view it rose to the level. I mean, that I was on the board of the ACLU in DC for a long time. That is exactly the kind of argument that normally liberals, right, and the courts would say, what you just said, what just came out of your mouth, shows that the statute on its face is overly broad, is unconstitutional, because no one can figure out what they're allowed to do and what they're not allowed to do. You have to go ask the prosecutor. That's not how criminal law works.
I think even the liberal justices today were reaching for some limitation on that concept.
Two of them were. Did you notice that? Ketanji Brown Jackson clearly was, and Sotomayor was. But Elena Kagan seemed, she didn't say much. So I was looking at my notes. She only asked a few questions that gave me any insight into what she was thinking. But she seemed basically fine with the government's formulation. Ship, what did you think of that?
I kind of thought her silence suggested maybe I'm
Mm,
not going to get out in front and try to defend this. I'm probably ultimately just going to be with the majority, and I'm not going to make a big deal of it. She can fall right in line with Ruth Bader Ginsburg's approach to these same kind of issues over 20 years is reflected in her votes. I actually thought Sotomayor was trying to save it more than anybody else, and while contingent Brown Jackson seemed inclined to try to fall in at the end, sort of the defense lawyer in her began to show through. Um, you know,
right. We talked about this the other night. Normally, liberals, and I thought especially someone who's a former defense lawyer, would have troubles with the vast overbreadth that the government is arguing. And it didn't seem like she was having that problem at the beginning, but at the end, she really started asking some very good questions.
I'd like to go to Justice Roberts because I think he 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 is he has already decided the case, and he has decided how he's going to twist everybody's arm to agree with him.
Well, and he was, I thought, uncharacteristically sharp with her today. Uncharacteristic for him. He's very congenial. He's a very agreeable gentleman, but he really kind of stuck it to her twice. Did you guys notice
oh
that?
yeah, absolutely. And then I agree with King completely. He basically his questioning I thought was essentially dictating the outcome.
Right.
And while while it was no fault of hers, the fact that the fact that he speared her with the decision from last Friday.
Last Friday.
It's like, and I thought about that. I thought, well, clearly she knew about the language of the decision from last Friday, and that it was going to be damaging. But she only had like 3 days to try to figure out how
Or what's she going to
what
do
she was
with
going to
it?
do with
Right.
it when she got asked about it, and he just went right at her. And I was like,
Yeah,
it
with
wasn't a
that.
very long decision. So he said it wasn't a very
Well, and you know
it,
what
it
was
said it wasn't a very long opinion, and I don't think he said, but when I looked at it, it's like, oh, by the way, it was unanimous.
right.
Unanimous,
So
12 pages.
12 pages. Not only that, I think maybe only lawyers would appreciate this. So I went back and looked at it. And because I knew what it was about from Friday, and most people probably saw the news coverage of it. It was the case where the court decided that these transportation workers do not have to go through I'm sorry, do not have to go through arbitration. Okay, that was the top headline of the news coverage. But for lawyers, if you dug down into it, the the basis on which Roberts, who wrote the opinion, ruled on it was the same kind of very technical statutory language interpretation. But
Latin.
on another level, what? Oh, the Latin. Yeah, I'm going to ask you about that, King, in a second. But on another level, the other thing is that case was, and this is the only way I can think of to describe this, that case opinion is basically a bitch slap of the Second Circuit. It's only 12 pages long. It basically tells them, you screwed this up. So they decided it one way and they decided it the wrong way. Okay. And one judge dissented and basically blasted them. And then the Supreme Court decided another case. And so the Second Circuit did a rehearing of their case in light of a new Supreme Court precedent, and they still came out the same stupid way. And so the Supreme Court on Friday ruled against the Second Circuit, and in very short, to the point, truncated language, basically telling them, you're wrong, get your act together. And so, did you guys notice when Robert said it was a very short opinion? Justice Thomas guffawed. He laughed really hard at that. And I think it's because he also thinks that opinion was more or less a bitch slap of the circuit. So, King, you and I were debating how much Latin was going to come out in this argument today. So, tell us
This
about
was
that.
all Latin. Justum generis,
Yes.
which means that when you have a collection of things or concepts in a statute, followed by a kind of follow-on catch-all type phrase, the rule is justum generis, is that whatever is common, the common thread of the various things in the first part of the statute control the last part, the catch-all, and define and kind of limit the catch-all to those types of things. You can't use the catch-all to go all over the universe with all kinds of new concepts. You're limited to what's come before.
Right. So Roberts did roll out the Latin. Did any of the other justices, both the advocates also used the Latin, but did any of the other justices?
I don't believe.
I know, I think Roberts was the only one who did too. But yeah, this is Ship's point though, is basically Roberts speared her. That's a good word for it, Ship. Basically saying, did you read my opinion from Friday about how this statutory construction is supposed to work?
And how it works
So,
here, uh, if that doctrine is applied, is you have the first part of the sentence. This subsection C of 1512 is a single sentence, and the first part is subpart one, and it talks about uh, destroying documents, uh, records,
records,
documents,
documents, and
etc.
objects.
It's evidence based. It deals with documents that might be evidence in a proceeding. And then the second part of the sentence, after the famous otherwise word, is and otherwise uh, uh, corrupts. What are the words?
Obstructs, impedes, or
Obstructs,
influences.
influences, or impedes. So the issue is do is obstructs, influences, or impedes. Is that meant to be as broad as it sounds, or is it meant to be a try to fill in the gaps of what we talked about in part one? And
Right.
and the Latin doctrine says it's a fill in the gap clause, not a omnibus clause that cover everything imaginable.
And then what was interesting is that Justice Jackson, Ship, this is where you were going, I think, about her. She sort of arrived at that same position by looking at the legislative history, the Enron application.
Her
Did you
questions,
notice
her
that?
questions at the end were, look, explain to me, we all recognize this provision was passed in response to the gap in the statute reflected from Arthur Anderson in the Enron case, or in the Enron investigation, the case against Arthur Anderson involving document destruction. And she said, how can we ignore that context that led Congress to pass this statute to solve that problem and follow you down this path into uncharted territory where there's no suggestion that Congress had any intention that this statute be applied in this manner?
Right. Looking at the legislative history, which for folks who don't know, one of the things the courts look at if the statute is ambiguous is, well, where are the materials that Congress used to put the statute together? So they will look at the arguments on the floor of the Congress. They will look at the committee reports, if there are any. They will look at sometimes even earlier drafts of the statute, what got changed. And lawyers call all of that stuff legislative history. And then there's a debate, a conceptual debate between the left and the right about when do you look at the legislative history and when do you just not need to look at the legislative history. Um, and so at the end, Justice Jackson is basically saying she looked at the legislative history and she doesn't see anything in there that indicates that the Congress meant for C2 to be outside of the scope of this question about documents. And so at the beginning, I thought she was on board with the other two liberal justices, possibly going to, go along with the government. But by the end, I really wondered, sort of like she did in the case about Colorado and keeping Trump off the ballot, if looking at the legislative history had persuaded her that she should really go the other way.
Yeah, I wouldn't be surprised if she votes with the majority but writes concurrence that's very narrow that says it's just because of that.
Right. That she doesn't see that scope is in the intent of the Congress. Now, Elena Kagan has the counter argument to that. She argued that with Mr. Green, Mr. Fisher's lawyer, at the very beginning of the argument, saying basically Congress recognized that there was a gap in the statute because of the Enron situation, that the government couldn't prosecute people for destroying their own records. They could only prosecute people for trying to get them to other people to destroy records, and they wanted to fill that gap. Everyone agrees on that. So what she's saying is that C2 was Congress's attempt to say we don't want to have to go back every time there's a new case that where people do something that's not already covered and amend the statute. So we're just going to put language in that says, oh, and if you try to do it any other way, that's also a crime. But the problem I have with that is that historically, that's exactly the kind of provision that judges and lawyers have said it's overly broad. Then you don't really have any idea what's criminal and what's not criminal. It's just, well, you're not allowed to obstruct, so don't do that.
So,
Didn't we all agree last night that we thought that was unconstitutional?
yes.
Yeah, and I think in a way, I think Kavanaugh asked a question that got at this point a little bit when he asked Green, assume that C2 is a standalone provision.
Right.
And without otherwise. In other words, it's just a line in the statute that says it's unlawful to corruptly obstruct, impede, or whatever an official proceeding.
Right, like instead of it being C2, it's
Yeah.
D. It's D as in dog.
And then he asked, would you agree that they could be prosecuted, that the J6 defendants, Mr. Fisher, could be prosecuted under this statute if it was untethered to C1? And he said, and I think I can't remember exactly what his argument was. He goes, well, that creates an overbreadth problem. And Kavanaugh agreed that, okay, yeah, because now you've got, and this kind of goes back to backtrack just a bit, to Kagan's ability, I think it was Kagan, I'm pretty sure it was, early on to defend the statute, when she was arguing the commonality. Okay, this is in the weeds to the degree that I don't really want to get into when you're trying to evaluate a residual clause. But the commonality between C1 and C2, what do they have in common? And she was arguing that what they have in common is the result. The result being the obstruction of the proceeding. That you have specific obstructive conduct in C1, and then C2 is just other conduct, and the commonality is the purpose is to obstruct the proceeding. And so she was saying, if that's the commonality, why isn't that perfectly
Perfectly
grammatically
fine.
logical?
Right. Right.
And which would sustain the statute. I don't think any of the other justices are the ones speaking up the most were going for that. And in fact,
Right.
I think Green missed an argument because it came too early. He missed the
Yeah.
opportunity from Thomas was telling him, look,
Yes.
well, somebody asked him later on, aren't you're arguing that this is the only way to interpret C2? You're saying that your way is the only way, and aren't you trying to do too much? And I thought that was an invitation to the rule of lenity, because what he was saying
Right.
is grammatically it can be interpreted either way. And if it can be interpreted either way as a criminal statute, that leads us to a certain outcome.
Right. Because if it can be interpreted either way, you guys, then there's another rule, the rule of lenity, that says if a statute is ambiguous and can be interpreted either, more than one way, then for purposes of criminal statutes, we should interpret it in the narrowest way. The idea being that, again, if the statute sweeps so broadly that it covers conduct that people aren't going to think is criminal, then that's unfair.
Gorsuch,
And
Justice
So,
Gorsuch was going that direction with
oh
some
yeah,
of his hypotheticals.
yeah. Let's get to that in a second. Steve wants to jump in here for a second.
I want to come in from a different angle for a minute, which is to make this point. If you look at in a big picture sense, most of the obstruction statutes, of which 1512 is only one, there are, as we all know, about 20 of them. Historically, obstruction of justice has been aimed at perversion of the judicial process. But what you have here is a statute that has been broadened to say that it applies not only to obstruction of a judicial proceeding, but also of executive proceedings and legislative proceedings. Official proceeding covers all three. And I think that has a really significant impact when we're considering the points that you've been discussing so well. And that is, if you're talking about the judicial branch, or if you're talking about an adjudication within the executive branch, a lot of the agencies do adjudications. People pretty regularly, pretty easily come to the conclusion that no, you shouldn't be able to try to influence those. Those are supposed to go off on the evidence. And if you're trying to tamper with the evidence or tamper with the witnesses or tamper with the decision maker, well, then you're violating the law and you ought to go to jail or get at least punished criminally. But here, they broadened it in a way that covers not only adjudications, but also other activities that the executive branch may engage in, or here, Congress may engage in. I mean, official proceeding applies to almost anything that Congress does. And the statute says, if you're going to read it as broadly as justice does, that it is a 20-year felony to corruptly, whatever that means, with a bad intent, engage in conduct that attempts to influence the outcome of a congressional proceeding. My God, K Street, they might as well just haul the paddy wagons out there and lock everybody up. This is an incredibly broad provision if you push it the way that justice does, given how broad official proceeding is and given where it fits into our constitutional and governmental scheme.
well, let me ask you,
And what's interesting
Steve.
there is that,
Let me ask you.
so folks know, the court is not going to decide whether this was an official proceeding or not. That was only touched on tangentially. They are not going to rule on that. And depending upon how they do rule on this, which I think they're going to rule for Fisher, but even if they do, that is an open question. Now, Fisher's lawyers tried today to say that they think that official proceeding only involves formal, official type, what we would call like a hearing or a trial or an adjudicative body's decision-making process. But the justices were not interested in that at all, it didn't seem to me. What do you guys think about that?
It wasn't, to me, it wasn't part of the question that was before the court. And I think that's why they were avoiding it. The question before the court has to do with the act.
Oh, Ship, I can't hear you at all. Can you hear me?
I can hear you. You can't hear me? How about now?
King, can you hear
I can
me?
hear you. I can hear Ship.
Aha.
Steve did
Well,
it. Steve did
I
it.
got kicked off for a second. Oh, I hate it when this happens.
Make somebody else a co-host. Not me. I've never done it. Still there?
I'm here.
Yeah. Well, then you and I will have a conversation.
Yeah, King, I can hear you clearly, but I can't hear Ship at
Okay.
I
all.
could be
Tell
the
her.
interpreter
Tell her.
here.
Tell
I'll be
her.
the intro. Let me
Tell.
be the interlocutor.
Okay. Hold on.
King, I'm going to try to make you a co-host.
I
Maybe
don't
that
know
will
what
help.
that
I
means.
just sent.
Hey,
Well, I just sent you an
I'll,
King.
invite for it, so
King.
just accept.
King. I'm gonna tell her.
Sometimes that seems to
Okay. I
help
can't shut her up.
link the
I can't shut
people
her up because she can't
because
hear me.
it's been my experience that a lot of times everyone can hear us talking, but sometimes we can't
okay.
hear one
Now
another.
I see I'm co-host. I'm not sure what that means.
Yes.
Ship, can you hear me now?
Ship's fallen off, so he may have lost his connection. What was he saying, King?
He was saying that he didn't think the issue of whether the session on January 6th to count votes was an official proceeding or not was part of the questions before the court. So everybody avoided it, and he's not surprised it didn't come up.
I could.
Right. Ship, are you back
Yeah,
now?
I,
Can I hear
I
you? Yeah,
I could
good.
hear you the whole time. I couldn't. I was trying to
Yeah,
tell.
I know.
I was
Frustrating.
trying to
Yeah.
tell King I was going to drop off and then come back to see if that solved the problem.
Yeah, it did. It fixed
Okay,
it. Thank
so
you. Yeah.
it's not part of the question that was before the court. The question before the court focused
Right.
on the actus rea of the offense, which is what the defendant did and whether that fit within the framework of the statute, not whether a congressional proceeding is an official proceeding as contemplated by the statute. Or
Now, Mr. Green did say that twice, though. He emphasized that point, but then the justices didn't pick up
it
on
might
it.
be something again they might drop in a footnote,
Yeah.
to
Yeah.
address without, but it
Yeah.
wasn't
He was clearly willing to answer questions about that, but he didn't
right.
get any.
But I think it's remember, the one of the doctrines of Supreme Court jurisprudence is, we only do as much as we have to do. We don't launch off into areas we don't need to go to if we've already got the basis for disposition on the case. Um,
Right.
so
Right. So everyone should not be shocked when they don't address that at all in their opinion, because they almost certainly are not
right.
going to.
There's something else. I wanted to ask Steve something. I presume he's still around listening.
Yeah, he's
Hey,
here.
Steve, now you've been an observer and a participant in the court, unlike anybody else on this spaces. I just was singularly unimpressed with Prelagar. And it's not the first time. I've listened to her before. I've not been terribly impressed. And it strikes me that it's a significant fall off from what you expect from the Solicitor General of the United States based on historical um, examples that have come before her. That's like the highest form of courtroom advocacy in the Department of Justice. And that position is coveted. It only goes to the best courtroom advocate. And she wasn't even close to that today. Not that she had anything great to work with, but I was just, I was kind of pulling my hair out.
You were
Yeah.
underwhelmed.
Well,
Yeah.
okay, but what I will say is this: my reaction is a little bit different than yours. I think she's a skilled advocate. I didn't agree with her argument today, but I think she is a skilled advocate. Whether she's at the complete top of the rank is frankly something that I don't know that I'm terribly well equipped to comment on. But I will note that, in fact, the Solicitor General is a political appointment, and that historically It has not necessarily gone to somebody that's the most skilled advocate. In fact, when Elena Kagan was made Solicitor General, she came out of the deanship, I believe, at that time at Harvard Law School. So she'd been a Supreme Court clerk, she'd worked in the White House. She's a brilliant person, but in terms of experience arguing before the court, she had none uh, that I'm aware of. Proligar, I don't know how you pronounce it. I believe is a veteran of the office, and she had to me that sort of polish. She was very smooth. She was assured. She wasn't intimidated. Um, I didn't like the substance of a lot of her arguments, but she's stuck with the the cards that she's been dealt, and she's got to do the best she can with them. So
I thought Roberts really stuck her on, she overstated this question about the Office of Legal Counsel's opinion that Mr. Green referred to. And she said that that opinion was not sort of officially adopted by the Department of Justice. And then when Roberts got a chance again, he was very sharp and asked her, well, what's the mechanism for DOJ accepting OLC opinions? And she had to concede that, well, what she said was, well, I should probably know the answer to that. And he said to her, yes, I think you should too. And then she had to concede that there really, to her knowledge, wasn't a process for doing that. So she had to back down a little bit.
And that's the wrong answer. The right
Yes, it
answer is
is.
their OLC. Their opinions are always, they don't have to be adopted by the Attorney General. That's why the office exists.
Right.
right. Well, I will, Ship. I agree with you in a more general sense. As a former prosecutor, one of the things I've always felt is that uh, your credibility is the single most important commodity you bring to the table in front of a court. I don't care if it's the Supreme Court or a court of appeals or a trial court. They get judges in general give deference, some level of deference, to attorneys from the Department of Justice because they of their position and because they think they are going to deal with them. They're going to be advocates, but they are going to deal with them in a straightforward fashion, and that you can rely on what they say. And when you start talking out of both sides of your mouth, I mean, it was shocking to me to hear that Neil Gorsuch had what on Friday or
Monday.
Monday had stopped the advocate from the SG's office in a case there to say what you're arguing here is the exact opposite of what you're going to argue tomorrow in the case we're now discussing. I mean, that is a very bad look. You know, the Justice Department is expected to give considered judgment and attention to issues. It can change its mind, it can change its position as long as it's got an explanation for doing so. But one thing it cannot do is to argue out of both sides of its mouth from the same SG's office, depending on what the case is. And to the extent that some of what you're picking up on is instances of that, as with the Chief Justice catching her, you know, the sort of, oh, you're taking liberties here, is the suggestion, then I agree with you. That's not good advocacy.
Yeah, and I guess what I would say is I have there's an angle here that I'm seeing that you didn't have the window into, and we haven't got to this yet. But the
Yeah.
most outrageous things she said was pay no attention to the 20-year statutory max because
Right. That was one of the times my jaw
the
dropped.
guidelines
Yeah.
are really not that severe. And in fact, oh yeah, there's this Brock case from a couple of months ago, and now the guidelines of these cases look like they're going to be, you know, roughly, I can't remember the number she used, 18 to 24 months, and you know, without
Right.
an aggravating factor, maybe 6 to 12 months. It's like, hold on.
Right. What realm of fantasy did you just
Well,
drop
there's
out
two
of? Because
problems with it.
that's not.
There's two problems with it. Showing the average sentence is only like 26 months. She gave the mean and the median. And it's like,
Right.
wait, that's not the guideline. The guideline is 41 to 51 for criminal history 1, with the enhancements, not just that the government was asking for, but that the government was demanding in plea agreements be stipulated to, even though there were real questions about their application, which, oh, by the way, the circuit court resolved in favor of the defense. The government was demanding stipulations to those 11 levels of enhancements that ratcheted up the guideline range to 41 to 51 months. And the government was, Jake Chansley had no criminal history. He pled guilty under a plea agreement that stipulated those two guidelines. They asked for 51 months, the top of the guidelines. Now, Judge Lamberth only gave him 41 months. But the point, and I've started to make this in a few places, the only reason that these sentences have been the in the neighborhood, for lack of a better description, of 41 to 51, maybe up to 54 months, a little higher if there's a criminal history, is because that's where the government demanded that they were. For her to now tell the court, oh, but really the guideline, and they're going to be lesser now. We're not, they ignore the 20 years, ignore the 20-year max because it really doesn't come into play. You know, it's like only because you guys have lost these arguments. And oh, by the way, the reason the mean and the medians are 26 and 24 months is because a few judges have varied downward from what you want, from the, not just the guideline, not just what they wanted, but from the guidelines themselves, because of downward variances, not because the guidelines are not, in the range of 3 to 5 years. They are. But then not mentioned at all, which I thought was, well, I mean, she wasn't going to mention it unless she was called on it. None of the judges were prepared, I guess, to call on it. It's like at least 2 judges have said, if 1512 gets tossed, we're going to vary upward so that we still have sentences in these ranges. So what's the good faith basis of this argument that the sentencing consequences are not really that severe and you should ignore the 20-year maximum when judges are telling you they're going to vary above the guidelines? So now the only cabining fact is the statutory maximum. Will some judge say, you know what, I'm going to give you 15 years on an upward variance because I'm so offended by what you did? End of rant.
Here, here.
Have we lost Leslie?
All right, Ship, can you hear me?
I can now.
King, can you hear me?
I didn't.
I can.
Yeah.
I really am getting very angry about this, the way this spaces thing works.
Are you getting?
And honest to God, if it continues to do this, I'm gonna find another platform for doing this, and still advertise it on Twitter so people can join. But I'm really getting very tired of it keeps telling me, oh, your connection seems to have been lost. Nothing has changed on my end, right? And then all of a sudden I can't hear you guys. I haven't been able to hear Ship, uh, for 2 minutes
I
here.
can repeat it.
So, Ship, can you hear me now?
I can. Can you hear me? Kingmaker, can you hear me?
I can hear you loud and clear.
Well, tell Leslie I can hear her.
Yeah, but can you hear Ship?
Yes, I can hear Ship. I can hear you.
And
Tell her you're.
I cannot hear Ship at all. I can hear
Tell her you're
you.
talking to me.
But if people can hear me, then wave at me. Aaron, can you wave at me? I see you there.
Leslie is asking if people can hear her. Or is she not? Are people not able to hear her?
Yeah. So it's completely frustrating, the whole way this technology is not working. Okay. Yeah. All right. So if people are waving at me, apparently they can hear me too. So I'm going to keep talking.
King, would you tell her that I can hear her?
Ship,
Even if
can
she
you
can hear
log
me?
out and log back in again? I hate to ask you that, but if I try to do it, I think it will end the spaces, and we don't want that. Um, so, Kingmaker, tell me where we are in terms of what Ship was talking about.
He went on a rant,
I could kind of see that that's what was
and
happening.
his rant had to do with uh, the disingenuous pitch that the Solicitor General gave on,
Mhm.
gee, this really isn't a big deal because guidelines apply, and whether we have a 20-year felony or something
Maximum doesn't
less,
matter.
you're going
Yeah.
to get the same sentence. And Ship went off.
Yeah. Well, and you should have, because that was BS, capital B, capital S, from the Solicitor General's office.
Can you hear me now, Leslie?
Yes, I hear you loud and
Okay,
clear now, Ship.
if we can get at least the first 3 or 4 lines, could everybody just give a thumbs up if everybody could hear me while I was ranting and raving there when Leslie couldn't hear me?
Yeah, wave at us again if you heard Ship's rant. Because the whether this statute applies or not is going to make a big difference in what people's sentences are, even considering the DC Circuit's recent decision in Brock, which we discussed several weeks ago on Twitter. That she stood there and told them, "Oh, don't worry about that because it's not going to make that much difference," is complete nonsense. And honest to goodness, I think to myself often, it's a good thing I'm not up on there on the bench, because I would be asking her, well, if it's not such a big deal, then why are you trying so hard to get us to give you all this power and authority to prosecute people for this? Why don't you just use the other statutes that you already have that are going to get you the sentences that you
Well,
want?
and I
And
think
one
it
of
was
them did ask her
I think it
that.
was Kavanaugh that asked her that. Kavanaugh said, "Look,
Yeah, asked
you
her
have this
that.
1752 statute that yes, it's being charged as a misdemeanor, but there is a felony provision there that if the person engages in violence or I think commits an injury, so in the commission,
10-year felony.
it's a
Yeah,
10-year felony. So to the
right.
extent, why not charge that 10-year felony for the people that are, engaging in violence or whatever you want, as your go-to felony, which doesn't seem to have any application problems, rather than this to use this C2 1512 C2 in a manner never before used and ask us to sign off on it.
Well, and her answer was completely circular, because what she said was that the other statutes didn't completely cover the defendant's conduct, reflect the severity of his conduct. And it's like, okay, but the whole point of this case is whether or not that conduct's covered by this statute. So it's a completely circular argument.
Well, the argument today sort of blinked. Nobody really nailed her on the fact of the matter is the Department of Justice sat down and looked at these J6 cases and decided and looked at the available criminal charges and decided that it wasn't happy with the menu that it had, and it wanted a felony that it could make on these people, and not just on the people that assaulted cops, because they obviously had assault charges on that. They wanted something that they could use on people who didn't assault anybody but would still nail them for a felony and get a big sentence. And in order to come up with it, some bright attorney came up with the idea of let's use 1512C2. That's exactly what happened. Everybody knows it, and people don't want to discuss it. But this is inventive advocacy by a prosecutor's office, which maybe when I was a prosecutor, I might have had some more appreciation for. Although, frankly, when I was a prosecutor in the U.S. Attorney's Office in D.C., I was on the local side, and most of the stuff I prosecuted was local crimes, murders, rapes, robberies, stuff like that. There's no mystery about what the elements of those offenses are. There's no getting inventive in a new way of charging those. But when you get into the federal side and into the white collar side, then then prosecutors get awards from the Department of Justice if they come up with some new novel way of applying the law to conduct that they don't like. And this is a real problem. It's been a problem for many years under both administrations. And that's at the heart of all of this, because that's exactly what's going on here.
Well, and Neil Gorsuch really skewered her today on that question of, because a lot of her answers were, oh, well, the thing that narrows the statute is that we have to prove it's corrupt. And there has to be a nexus between that and the official proceeding. And it has to be more than de minimis. It can't just be minor, Mickey Mouse nonsense. And my problem with all of those arguments is that none of those things are in the statute except for the corruptly part. And who the hell knows what corruptly is half the time? The definition changes across the law. But all those three things combined boil down to, if the Department of Justice decides it's obstruction, it is. And if they decide that it's not obstruction, it's not. And normally, when the government says that's the way they want to interpret a statute, the courts say that means that the statute is vague and overbroad because regular people cannot figure out what is in and what is out, and they don't have the ability to call up the prosecutor's office ahead of time and say, if I do XYZ, is that obstruction in your opinion or not?
Yeah, that's the key right there, is that if you have to call the government to find out if what you want to do is lawful or unlawful, then the statute is a problem.
And Chip,
Right.
when you do call, you'll get a disclaimer at the end of it that you
Right.
can't rely on this.
Yeah. Let me address
But also, you're now under investigation for whatever it is you were proposing.
I'm really sorry you missed my 2-minute rant on the whole sentencing issue, because you would have blocked that. I'll give that to you privately offline, but hopefully everybody else, seems like everybody else heard it. King heard it. It's pretty good, wasn't it, King?
Yeah, I'm pretty sure I know what it is.
But there was another.
But Neil Gorsuch.
There was another one. I got an uncredited shout out today.
Oh yes, tell us about that. You tweeted about
that. That was equally misleading and duplicitous, because she was talking about how burdensome the elements of this statute really are on the government, and how they've had to be discerning in which defendants they go after. They have to have proof of intent, and the elements are not easy. And even when they felt like they charged cases where they had evidence beyond a reasonable doubt, that there have been acquittals, and even in those cases where they were confident in conviction, that people have been acquitted. And she said, for example, there was an acquittal where the question was whether or not the defendant had knowledge that the proceeding was still ongoing, and his testimony that he did not have knowledge was credited, and he was acquitted. And then there was another where a gentleman was acquitted because the evidence that he was maybe waved into the building by law enforcement and wasn't aware that it was unlawful for him to enter. So, and she set this up as like, well, these are examples of where this has been a problem for us. Well, there's only 2 cases.
Right. There's only two cases. And you're supposed to go through the whole thing of being put on trial, for your liberty.
But now let me tell you, one of them was Dave Mahaffey, which was my client, which was the first felony acquittal.
Your case.
Now, but let me tell you why we were able to pull that off. We were able to pull that off because Dave Mahaffey was never interviewed. That means what we put out in his testimony in the defense case, the government had never heard. They weren't able to try to manage their way around it in the presentation of the government's case. And his testimony was, look, in 2016, I watched the certification proceeding on TV because Ohio was being contested. And I watched it, and it was rather perfunctory, and it was over in a half an hour. Even though there was this disputed election over the Ohio delegates,
didn't take that long to do.
They dealt with the objections. They overruled the objections. They certified the vote. Donald Trump was declared the winner. So his testimony was, so when he got to the Capitol, and we could establish the time he got there, didn't get there until 2:30. He and his family were at the very tail end of the crowd, moving from the ellipse to the Capitol. They weren't in a hurry. They were taking their time. On the way, they heard the conversation, the buzz in the crowd, that Mike Pence had refused to intervene, and that the certification had gone through and it was over. And combining what he'd heard with what he knew from 2016 to be a rather truncated proceeding, by the time he got to the Capitol 230, he thought it was over. It was done with. And we had agreed that the relevant element of the 1512 count was that he have knowledge that the congressional proceeding was taking place. Well, the government, he did not have social media. Didn't have, the government couldn't point to text messages or social media or anything to raise this question or to try to get past their burden. And I argued it to McFadden as a failure of proof on the question of his knowledge. His testimony, if credited, was that he had an understanding and a basis for understanding that the proceedings had ended. So when he went into the building, he did not know that he was interfering with anything. He actually never went into the building, but he got close. And in closing argument to the government, McFadden looked at the prosecutor and said, seems like Mr. Shipley has a point. Is there any, knowledge is an element. What evidence did you present that he had knowledge? The best the prosecutor could muster was, well, he came on January 6th. And everybody knows
That's what
on
was
January
happening.
6th, that's what was happening. And
Yeah.
McFadden
See how I can predict that, what they're going to argue?
and
Right. Yeah.
McFadden just shook his head and he almost laughed. He goes, that's not really the point. The point is when he went in the
Yeah.
building.
Right.
And he acquitted him on that basis.
Right.
The only reason we were able to do that was the government didn't know it was coming. So for her to say, well, we've had trouble proving some of these cases. Even when we thought we had evidence, we were like, she took out the unicorn and used the unicorn example as a basis to establish how difficult it is for them to actually win these
just
cases.
how high the wall is, how tough it is. I'll tell you what, folks, pro tip. Anytime a prosecutor's telling you how difficult it is for them to prove something, that's unmitigated horseshit. They don't believe that for a nanosecond. So the other thing is, King, is that you?
Yes, we're talking about what does corruptly mean. And
Right.
we heard in an argument yesterday that you can flip a coin sometimes as to whether something is corruptly or not.
Right.
And to hear her get up and tell the court that that word is the major limiting factor on this whole statute, that we have to prove corruptly. That is a high bar, she says.
Mm-hmm.
That that's so much horseshit.
Right. That's laughable nonsense, is what that is. Well, she told the court there were three factors that they were using to decide, to make this division of whether people got charged with 1512 or not, whether they could meet this high bar of corruptness, right? And she said that those three things were whether they knew that the proceeding was ongoing, the certification of the votes by the Congress, whether their intent was to stop that, and whether there was any evidence that the person was using violence or was prepared to use violence, whether they took handcuffs or weapons, whatever, and that's the basis. Those three things are the basis on which they were distinguishing their making their charging distinctions. And I sat there listening to that thinking, the Department of Justice has charged the former president under this section. And how in the world is she going to justify that on those three factors? Because, okay, maybe you could prove that Donald Trump knew that the proceeding was taking place. Okay, that might be easy. What proof in the world are they going to have that he intended to stop the proceeding? His whole point following John Eastman's theory was that Ted Cruz and those other guys were going to lodge all these objections and they were going to delay this, right? So, or that Mike Pence had power to, to do X, Y, and Z about it, so that more time could be had to determine the appropriate slate of electors and all of this kind of stuff. There's no independent objective evidence that Trump wanted to stop any of that. To the contrary, he wanted to use the procedure to advance his cause. Whether you agree with whether he's right or not just doesn't even matter, right? And of course, there's fucking zero evidence that Donald Trump personally was, using any violence. So I listened to that thinking, he's the most high profile person, obviously, that they've charged with this section. And his case does not fit into these three factors that she just laid out. And so they just say these things like somehow nobody's going to notice that.
Leslie, it's worse than that. You remember when I think it was Gorsuch asked about Federal Rules Civil Procedure Rule 11,
Yeah.
and
So people know Rule 11 is the rule that says lawyers have to have a good faith basis for filing pleadings.
you're prohibited from filing pleadings and making arguments in court solely for the purpose of delay. And one of the elements of the C2 part is not just obstruct, not just influence, but also impede, which
Impede.
they kind of agreed could mean delay. So Gorsuch asked the government, "What about a lawyer who violates Rule 11 in a civil case uh, and intentionally throws out frivolous arguments and pleadings to delay the proceeding? Does
Right.
he go to jail for 20 years?" and
Right.
the correct answer was,
I know some lawyers who would qualify
yeah,
for that.
the
So
correct answer was, well, 1515 has an exception for lawyers who who make arguments in court. They're accepted. They're not covered by
right.
this. But she didn't answer the question. What about the client, like
Right.
Trump? He's not a lawyer, but he's following his lawyer's guide here. And so basically, the government's position is, well, the statute exempts the lawyer, but we're going to go after your client.
Right. Fantastic. Right. It's like they don't even hear how horrifying these arguments are. Right. In rebuttal, Mr. Green pointed out that the government answered two of the justices' questions in a way that indicated the government's position would be that peaceful protest could potentially violate this statute. So that if people had rallied around the Capitol but not entered the Capitol building, and they just refused to disperse when the police ordered them to, that even if there had never been a riot, but simply loud protests, that the Capitol's security got concerned might turn into a riot. That if in fact the Senate had delayed, the Congress had delayed the vote, that would also qualify. That's just mind-boggling. That's what the Solicitor General thinks. That's what would amount to either First Amendment protected activity or maybe crossing the line over into civil disobedience. But that behavior, nonviolent, would result in people being prosecuted under this statute is insane. But Neil Gorsuch and Sam Alito, I mean, they were all over that. They just scorched her with, or you're not going to prosecute this, and this is in, and this is out, and this is whatever. But stepping back, I was just horrified at the inability of the Solicitor General's representative to think, you know what, that doesn't sound right. The words coming out of my mouth don't sound consistent with our
Yeah,
values.
and this is why one of the reasons why I shaking my head about this is not good lawyering, because
No, it's not.
it's built upon the indefensible premise that we will only act as prosecutors benevolently.
Right.
That you need not
Everyone knows that's
you
not
need
true.
not fear that we will abuse this power we're asking for, because we've never done that.
Right. And we wouldn't. You can trust us.
Exactly.
Take our word
And
for
that's
it.
just,
That's
I
craziness.
mean, it's not going to fly as a historical matter, but it's also not going to fly as a
Right.
legal principle.
Right. Normally the court, you guys, so you guys know, normally the court rejects that argument. They normally reject the argument that, well, just trust us, we'll use this statute carefully with good discretion. Normally the court says that's not the basis on which we make rulings. So I'll be interested to see what they do here. But Neil Gorsuch is on board with the memes too. I mean, he asked her about mostly peaceful protests, not hitting the bar, and she just blew by that like she didn't even recognize that as a thing. I thought, well, okay, but Neil, he's up with the memes. So, well, you guys, in terms of the outcome, I think Fisher wins. So let's take the poll here. Steve, are you think Fisher's a win? He's nodding yes. He says yes. Kingmaker, your view?
Yes, Fisher wins.
Yeah. Ship, you on board
Yeah,
too?
yeah, I think it's consistent with where we were all 2 nights ago.
Yeah. So at least 5 of them, and probably 6, maybe 7 or 8 of the justices, right?
As I said before, I think Justice Roberts is going to twist some arms after using Friday's decision on the Latin.
Oh,
Yeah, no, you know,
so
I think, yeah, I think the question posed is a little bit difficult to get to 9-0.
I
I
do
think
too.
some of the justices are of the view, or will express the view, and might dissent or might, partially concur, partially dissent, are going to be of the view that the government can use the statute, it just needs to do it a little different fashion.
Right. And Sotomayor and Ketanji Brown Jackson tried to push the Solicitor General in that direction and ask her, what sort of middle ground positions would the government be happy with? So that would seem to indicate that maybe that's where they're falling out, those two.
Yeah. So concur in the outcome as to Fisher
Right.
specifically, but write
Right.
separately to say that they don't, as a categorical matter, find that the C1, the C2 being cabined by C1 is necessarily correct as a statutory construction.
I don't know what other limitation there maybe be opining, what they think, but rather than it being effective legally, the limitation, because I think it's going to be very difficult for them to find a strong middle ground.
Yeah,
That's going to make any
yeah,
sense.
I'm thinking about, what I thought was a ridiculous hypothetical, I think introduced by Barrett, which was, well, what about the theory that by interrupting the proceedings, they were preventing the ballots from getting to the counting location, and that is evidentiary impairment. It's like,
I think that was an inartful way of trying to get to Smith's theory on Trump. Right? That seems to be Smith's argument, that even if the court says 1512 doesn't apply to the riot in general, that his argument against Trump in his case in front of Judge Chutkan is based on obstructing the actual or falsifying the actual elector certificates.
yeah, I think that I actually think that there might be behind the scenes, in the hallways and in the small conference rooms, some view that they need to categorically eliminate 1512 to prevent Smith from trying that, because I think what they don't want is to have to reverse that down the line after a conviction has already been entered.
Yeah. Right. Well, that's clearly where it's headed. And depending upon how they rule, what they actually say in the decision, that issue is still alive potentially,
Yeah,
right?
it changes Smith's case dramatically, but
Yeah.
he's still in D.C. and he's still got a friendly judge, so he can get to the same
Right.
outcome, which they would then have to review, and it changes his case dramatically in that false electors are no longer about the violence around the Capitol. So I don't know on what theory under God's green earth the judge would allow the evidence of the violence in under 403.
Right. So people know 403 is the part of the Federal Evidence Code, which says that the judge can keep evidence out or let it in, but can keep it out if it's prejudicial, as to some things, even if it's
substantially more prejudicial than probative.
right. So that it's so the sort of the non-lawyer word way to understand this is that the evidence goes to some of the issues in the case, but maybe also would cause a jury to have an overreaction to the evidence in ways beyond what it's really worth in terms of value as evidence. So there's a bunch of different formulations under 403 where evidence could be relevant and useful for one purpose and therefore admissible, but still not get in because it's doing something that's problematic in other ways in the case. So judges make those rulings all the time, most of which are never reviewed by the courts of appeals because it's just not something that bubbles up. It's never ultimately the most important issue in the case. So the judges there have a lot of latitude. But if the Supreme Court strikes down this application of 1512C2 and Jack Smith wants to narrow his case against Trump to try to fit into whatever the Supreme Court leaves on the table, then what Ship is saying is that that could cause Judge Chutkan to have to make rulings that things that might in theory be admissible on the 1512 are still so prejudicial that they can't be let in anyway. Now, I don't have a whole lot of confidence that Judge Chutkan is going to make those rulings fairly in that case against that particular defendant. But in theory, a judge could make those rulings in an appropriate way. So we'll see what happens there. But it seems to me from Smith's filings that he's going to try to go down that road. King, do you agree?
He says he is. I still call bullshit on it because it makes no sense. It's illogical. It doesn't even fit C2 as interpreted by the government because it.
Well, the argument would be that the certification, the documents, the paperwork for the electors is false. And that by trying to inject these false documents into the congressional proceeding, that fits into C2. I'm not saying I agree with that, but is what the argument would be. It still also leaves open the argument about whether the congressional proceeding that day is an official proceeding for purposes of this statute.
Let's assume it is. The it is what he's. It is what it is. It's a signed statement that here is a set of electors that Congress you should vote for, and it doesn't it's not accompanied by a state government official certificate saying they're official. So they're unofficial electors competing against certified official electors, and that's the kind of regime that the Electoral Count Act contemplates.
Right, and that has been done in the past. Right, it really does raise the question of, are those documents false? I think no,
They're
but
not only false,
yeah,
what all they do is tee up the issue to be decided by
right,
Congress.
right,
It's just
exactly.
an
So,
alternate slate. That's all. It's not. It's just an alternate slate if Congress disqualifies the slate transmitted by the governor.
right. And so, we're back to the same arguments we always keep talking about with these knuckleheads, which is calling them fake doesn't make it fake, right? Saying, oh, it's unlawful doesn't make it unlawful. You still have to look at the facts and the law to decide whether it's fake or unlawful. But these folks want to just slap labels like that on things. So, but to be clear about what the argument is, that is what Smith will argue is that okay, if the Supreme Court says we have to have an evidence issue, at least as to Donald Trump, there's an evidence issue, maybe not to any or very many of the other J6 defendants, but at least as to Donald Trump, there might be, is what he's going to argue, because these documents are at least documents, which is what the statute is talking about.
Which brings me back to Justice Gorsuch's comment today, his question about Civil Rule 11,
Right.
whether the attorneys can get caught up in this broadly read statute. And the answer was no. Of course, attorneys are exempt. Smith says we just
So
get to
convenient
go.
that we exempt
We,
ourselves.
we can't convict Eastman, you came up with this scheme. We just go after the
Right.
client.
Well, the other thing I wondered about is Eastman is an unindicted co-conspirator in Donald Trump's case for that 1512 charge, right?
Yes, exactly.
How can that be when under that specific section of 1512 lawyers who are giving advice or making representations are exempt? How can he be a co-conspirator then?
And how can a client relying on that advice have corrupt intent?
Right. Wouldn't that apply to Clark too? Isn't he one of the unindicted
He
co-conspirators
is,
in that case?
yes. His
Right.
his role was different from Eastman, so
Right. Yeah.
he was working inside the DOJ. Uh,
Right.
the issue on the table being whether he would become the new acting attorney general and write letters to Georgia and other states, maybe suggesting they look deeper into fraud in the election. Uh, that's really beside the point on this official proceeding part. But the Eastman versus Trump issue, it's there in spades after today, and I don't think the Solicitor General did Smith's case any help.
No, I didn't think so either. So we've talked about her a lot. Let's talk for a minute about Mr. Fisher's lawyer, Mr. Green. I thought he did a very good job, and especially in the rebuttal case. What do you guys think?
I thought he did. He missed some points though, but
Yeah.
like particularly up front. Justice Thomas wanted him to go down a couple of roads that he did not take.
Thomas gave him a
Yeah,
softball and he missed it.
but he was well prepared and did a good job.
Yeah. Ship, you got any thoughts on that? Oh, Ship has dropped off again. Looks like he was trying to unmute himself and he canceled himself. Ship, jump back on there if you can hear me. So I'll point out one thing that he did well, Mr. Green, in rebuttal. The government had argued all this craziness about, oh, that there has to be a tight nexus between the conduct and the official proceeding in order for us to even consider charging these people with this. And then Mr. Green stood up in rebuttal and said, well, actually, subsection, I think it's F as in Frank, in the statute says that the official proceeding for purposes of the statute doesn't have to be ongoing and doesn't even have to have been initiated yet. So that provision is in there because in the past, defendants would be able to get out from under this statute by showing that there was no official proceeding existing at the time. And so the case law said, well, that's right. If there's no official proceeding, then you're not, how can you be obstructing it? How can you be impeding it? And so this provision is now in the statute that says the official proceeding doesn't have to be ongoing, nor does it even have to have been initiated yet. Now, the idea there, that may seem odd to people, but the idea there is that if the government is preparing or the lawyers are preparing for a trial, they're preparing to put information into the grand jury. That, it's not like we want people intimidating witnesses or destroying documents. in a situation where they know there's an investigation and there's definitely going to be a case, or it's highly likely that there is. So they broadened the scope of the statute. So Mr. Green correctly pointed that out, commenting that, this whole idea that there has to be this tight nexus, the statute itself does not require that.
But we sure heard a long argument by the Solicitor General explaining how that was one of the main things that kept
Was saving
this, yeah,
their
they kept
interpretation of this
limits
statute.
around their
Right.
theory.
Right. Yeah, exactly. So, Ship, did you have any thoughts about how Mr. Green did, Mr. Fisher's lawyer, today?
I didn't, because I didn't think they really taxed him too much.
No, they didn't go after him like they did her.
But representing the appellant, he had to go first. So it's like, well, this guy's first. I guess we've got to ask him some things. And a couple of the comments, some of the questions I thought were pretty much softballs, setting up what they were going to do to the government. And the only place where he really got taxed was, well, isn't the plain, regardless of how you evaluate how the statute is being employed, which might be objectionable in some fashion, the plain language of the statute, if you don't associate C1 and C2, what they're doing fits within the plain language of C2. Setting aside the question of overbreadth and superfluidity, and that's a new word for me. I had not used that word before in context, but I will be using it again in this context. And I thought, I think it was Sotomayor that brought that up. So, well, I'm really having trouble with this because isn't there superfluidity all through the obstruction statutes? They overlap with one another, and it's like, yeah, but not like this. Not with a provision that essentially swallows everything else. Now, I actually thought it was
and that's what so people can understand. So superfluity is close to another word that they use, surplusage. Okay, which the idea there is that the government's interpretation of this little subsection is so broad that you might as well not have any of the rest of these, or a lot of the rest of these 20 statutes that Steve was talking about, because if that one section is interpreted so broadly, you just don't need all of the rest of them. And normally courts refuse to interpret statutes that way because that doesn't make sense. Congress doesn't write statutes that, at least in theory, they don't write statutes for stuff that they've already well covered the field. So, but yeah, superfluity was mentioned several times.
Yeah, and then the other argument that I thought was a little too cute by half by Preligar was her response to they didn't phrase it this way, but the response to what I can't remember, Nichols said it in the district court or the appellate court, hiding an elephant in a mouse hole.
It was Nichols. He's quoting an earlier old case, but it was Nichols who did that.
Place this extraordinarily broad passage in the subsection of a subsection of a statute. And Preligar tried to finish. Well, I don't think it's surprising at all, because if you look at the context of all of 1512, 1512A is about murdering a witness, and that has the most egregious offense conduct, and so it has the strongest penalty. And then if you go down to D doesn't have a specific intent requirement or tied to an official proceeding, and that's only a 3-year statute. So if you're looking where within the statute to put this, seems like C2 is a good spot.
Where are you going to put the nonsense? Put the nonsense in the middle where people won't notice it, right? She might as well have said that, because that's what she said. Yeah, no, a lot of it, I just thought, oh. Now, I do think that Justice Kagan came the closest to explaining what actually is going on with that section. She said, look, when Congress passed this statute in the face of the Enron problem, they did not want to have to go back after every new way that people can think up to obstruct the system and keep adding sections. So they decided, let's just take the opportunity that we've got now, since we're amending the statute anyway, and say, oh, and also you can't obstruct this stuff in all these other ways either. We don't know what they are, and we're not going to bother to, draw up a list of 100 different thousand ways that people can do this. We're just going to say, in general, you're not allowed to do it, so don't do it. And she said that, that's kind of like, that seems like that's what they're doing. It's a stopgap, right? What's the other? Backstop is the
Backstop.
other
Yeah,
one.
yeah.
Backstop and a gap
Right.
filler, right? Okay, I think she's right
I think
about
she is
that.
too.
That's what the Congress was doing. But the problem is that the way that they did that is
Yeah, exactly.
unconstitutional.
It's like that. I think she's exactly right. That's exactly what Congress
Yeah,
intended.
that's what
And the
happened.
response in a criminal context is, yeah, but you can't
You
do it
can't
that
do it
way.
that way. Right, exactly. You can want to, but you can't actually write that statute. And if you do, the courts are not going to enforce it. So, yeah. So, all things considered, you guys, we think Mr. Fisher won his case today. We'll see how they articulate what the narrowing of the statute is. And depending upon what they say, well, no matter what they say, it's going to have a big effect on these January 6 cases. And so, Ship, I want to talk about that in a second, about like the aftermath.
I
But
want to add
um,
one thing here real quick in the middle. We got lots. I don't know how many people are watching or listening to this. It seems like a huge crowd here tonight. I want to get on a little bit of a hobby horse for 30 seconds. I said tonight.
right. Yes, we
I
will.
said 2 nights
No,
ago.
wait. We no. We will definitely do that. Hold on one second. So what's going to happen is Mr. Fisher's going to win. The effect of his case is going to be to create a lot of problems for the government going forward, because they won't be able to prosecute stuff the way they've been. It also will create a ton of people who've already been prosecuted who will now have the ability to use this case to their advantage, which is what Schiff wants to talk about. We're gonna end with him on
Now,
that.
something else, something
Um,
else. We'll
wait.
get to that at the end, but
Oh,
there's
oh,
something else
okay.
I want to
All
mention
right.
real quick.
Yeah.
Something I mentioned 2 nights ago was a
Okay.
lawyer that deserves a lot of credit, whose name doesn't appear anywhere and is not well
Oh,
known.
yes.
It's a New York lawyer named Nick Smith. He's represented several January 6 defendants. He represented Ethan Nordine in the Maine Proud Boys case. He's represented numerous other defendants. I've gotten to know him real well over the 2.5 years I've been doing this. We worked together a lot. We worked together a lot on this question. He did most of the work. I did most of the kibitzing and phone calls. Um, but he deserves a lot of credit for this. My hobby horse is the individual and lawyers who deserve no credit for this, but are attempting to take credit for purposes of fundraising, is Jake Lang and his lawyers. When this case was taken up back in December, Jake Lang is a J6 defendant sitting in jail for 3+ years. He went online and said, the Supreme Court has taken my case. We need to raise money for my lawyers to prepare for the Supreme Court argument. The Supreme Court didn't take his case. There were 3 cases available. The Supreme Court took the Fisher case, did not take his case. I've now seen today that Jake Lang supporters are claiming, victory, and that they're responsible for it, and that if it hadn't been for Jake Lang raising all this money and paying his lawyers, that this outcome wouldn't have been possible. Absolute 100% unadulterated bullshit.
Okay.
That
So
end of rant.
what's going to happen is, right, end of rant. So what's going to happen is that people who had this charge in their case are going to be able to take advantage of this ruling, which we think is going to go in Fisher's favor. But there's going to be a lot of complications for that, because depending upon whether you raised it or not in your case earlier, depending upon whether you pled or whether you went to trial, whether you're still on appeal, whether you're not, there's going to be a lot of issues there. But we're going to talk about that as our very last topic. But setting that aside just for a second, the other thing that will happen is, depending on exactly what they say in the opinion, exactly how they, scope out what is the scope of this provision, is going to affect how much it affects the former president's case. Whether Smith will still be able to try to bring it, whether Trump will have better arguments than he already has for that it doesn't apply, and if that case ever goes to trial, which I kind of wonder about, what exactly will be put in front of the jury. And as we've been saying, the Supremes are not going to answer this question about what the meaning of official proceeding is. So that issue, I think, is still going to be lurking in his case, no matter what the Supreme Court does with this one. So turning to this last issue for Ship. Ship put out an interesting tweet tonight about, because there's going to be all these defendants who are differently situated, but still had this 1512 charge in their case, that they're going to need help to figure out whether this is going to help them or not help them. And some people who even are finished having served their sentence are going to be able to take advantage of this potentially to help use Fisher's case to get this off of their record, and potentially other legal consequences too, if it's the only felony that they had in their case. So there's going to be a lot more legal work to be done on that, and whether people and to what extent they can take advantage of it or not. So I wanted to let folks know, Ship, about your tweet that you put out tonight saying that you're open to taking those cases, assuming the Fisher case goes the way that we think that it should, and that you want people to sort of send those folks in your direction. So anybody who's on the call tonight, go over to Ship's Twitter. He put this tweet out today explaining this. We want to broadcast that far and wide so that if people are in the situation, because they may not be following what's going on, right? Especially if they're like over and done with their case. If people are in the situation where they could benefit from this, we want to send them in Ship's direction, so he can help them evaluate whether or not they can take advantage of it in a practical way or not. So, Ship, you want to talk about that for a second
Yeah,
before we let go
yeah. I
tonight?
was, I have, taken on a lot of clients who were, unhappy or simply uncomfortable with attorneys that were representing them, some of whom they had hired and retained and weren't happy with, but many of whom were, financially in a position where they just had to accept a court-appointed lawyer and weren't happy with the advocacy or the effort being put in on their part. So being able to raise money as I've been able to, which has been continues to shock me. I've been able just to do the work without worrying about whether the clients, for the most part, could pay because the money's been coming in through donors. Um, and so I kind of started thinking about this after our spaces on Sunday, and I actually put out the tweet yesterday. But I started thinking about this after the spaces on Sunday, and then Leslie and I were doing some back and forth on what are the possible vehicles that can be employed and what obstacles might exist for various defendants given how their case has proceeded. And there are problems. There are going to be problems for some being able to go back to the trial court, to the judges that sentenced them, and try to have some relief if the outcome of Fisher is, what we expect it to be. And it's going to be complicated, and there's going to be several paths depending on how their case specifically went. And a big issue that exists in this kind of situation is what is referred to, and help me here, Leslie, is what is referred to as a defaulted claim. Defaulted claim, is that the right?
Right. Yeah. There's a rule that if you're on collateral attack, like a habeas corpus,
Your case is over. Your
you
case
can,
is final.
your case
You
is,
either
or
you
you
either
can,
waived
yeah.
appeal or you've already had an appeal lost. I don't think there are many of those. Mostly you either waived appeal and your case is final, and you have to have a vehicle to go back to the district court judge, have your case reopened. Um,
Right. And that's called, lawyers call that collateral attack. Sometimes it's called habeas corpus. And, but there are rules about what you can and cannot bring on this mechanism. One of the rules, unfortunately, is that you can only make claims for something that you claimed earlier. And I know that sounds crazy to people, but the idea of habeas corpus and collateral attack is that through the course of your first case, your regular case, your trial and your appeal, that maybe your constitutional rights were violated or there was some other problem in the case, and you flagged it and you didn't get any relief, but now you're bringing it back again because something has changed in the law or there's new evidence in your case or you're claiming that your lawyer didn't put it forward. So one of the tests has to do with whether or not you asserted this claim before, because what the courts and the government don't want is people basically bringing second appeals. The habeas corpus is supposed to be like a stopgap backstop mechanism for people who, where there's a serious problem in their case that they tried to raise and for whatever reason, that didn't work.
or or
So
or as is the case here, People tried to get the 15-12 count dismissed, lost
Right.
that effort, pled guilty, and now their case is over. Okay.
Right. And so they couldn't appeal. So now they're stuck with this collateral attack.
Yeah.
But
depending.
what yeah, depending upon how that worked out dictates what you can argue on your collateral attack. So some of these folks, maybe they raised it, but some of them, maybe they didn't, this particular argument. And how much relief they're going to get, or at least the arguments that their lawyer is going to have to make, is partly going to depend on whether they previously raised it or did not raise it. If they did not raise it, then the courts call that a default, a procedural default. And if they procedurally defaulted, they can sometimes still bring the argument under an actual innocence theory. So, Ship, that's where you were going with
Well,
that?
I mean, and cause and prejudice. You have two alternatives. The case we
Right.
talked about, they
Yeah.
only brought the actual innocence claim. They had the cause and
Right.
prejudice opportunity. Now, these are different theories upon which you can get a procedural default excused. So
Right.
the tweet was simply that, look, if your case is over or you had a 15-12 and you're guilty and you're just not confident in going back to the same lawyer, but you can't afford to hire a new lawyer, you can't get an appointed lawyer on 2255. You can't go to the court and say, give me a lawyer. You have to, it's just not provided for in the law. You don't have the right to counsel in a 2255. But, as long as I can keep raising money, I will do these cases. And I think, I at this point, I have appeared before just about every judge. And in one fashion or another, I've done okay with just about every judge. I don't think I have a bad relationship with any of the judges. And some of this stuff is going to require cajoling the judges into going along. If you can win these things in the district court, the government's ability to take them up on appeal is very limited. It's going to come down to getting some of these district judges to go along with it. And
all right. And so I want people to understand clearly what we're talking about. So Ship does the work. He gets paid for doing the work, but the clients, for the most part, are not paying his bill. His fees for the work are being covered by donations that people make to help these people with their cases. So I want people to clearly understand what we're talking about because it involves money. So Ship is not asking for people to he's not saying, look, these people need to come to me so that I can make more money.
Let me explain how I've done this, because I've probably never done this in spaces with you. And I give this explanation to the clients when I talk to them. I'm not asking anybody to go borrow money against their house or raid their kids' college fund to defend themselves. I've not turned anyone down on the basis that they couldn't afford to hire me. What I have asked, and what everybody has gone along with, is if they've raised money themselves for legal defense, that they kick that into the fundraising pot. If they have some money that they are able and willing to part with, sort of as a community effort, then they kick that into the pot. It's very much, this is the example is very much like a collection plate in church on Sunday. If the people that have some to give it, the people that don't have anything to give don't, and we all move forward.
Right. So basically the fees are covered largely by other people donating money to pay for these folks' representation. As far as I'm concerned, I'm not taking any money at all, period. Right. I will help Ship with legal analysis. We talked about, I'm going to probably help write a memo to, work through all these different kinds of the ways this case could result in help for people. I'm totally 100% donating my time and effort on that. No money is coming to me, period. So we are not trying to raise money for ourselves in the way that other people are like, oh, hire me, and I'm going to ask you for a huge retainer. That's not happening. Okay, so I think that's all we have for tonight. We went a bit longer than I thought we would, but we got worked up about a couple of issues. So, Kingmaker, do you have anything you want to say to sign off on?
No, I'm dozing off here. So
Well, my hubs is as well. It's getting kind of late for the older generation, so I think we should say goodnight for the night. And I want to let people know we are probably going to do another Spaces on Sunday about the immunity argument, which is next week in the Supreme Court, next Thursday, not this Thursday, but next Thursday. So be on the lookout for that. Okay. All right. Thank you so much, guys, and we'll talk again
Good
later.
night, all.
Good night, all. Bye.